Hello, and welcome to the Divorced Dadvocate, divorce support for dads, where we help dads create a healthy and less traumatic divorce. My name is Jude Sandoval, and I'm your host. I created this podcast in the Divorced Advocate community as a result of my own high conflict divorce, and because you as a dad deserve all the resources necessary to thrive through this challenging time. I encourage you to check out our website at thedivorcedadvocate.com, where there are resources that correspond to this episode, as well as free access to our membership community, where you will find live meetings, free workshops and courses, private discussion groups, and more. And now, on to this week's episode. Hello, and welcome to the Divorced Dadvocate, where we help dads create a healthy and less traumatic divorce. My name is Jude Sandoval, and I'm your host today. We are going to be talking about a very important topic today, which is preparing for the potential of a custody battle. But before we get into that and I introduce my guest, I would want to remind you that the divorce quiz is still up at the website. It is an awesome tool to allow you to gauge where you're at in your divorce or post-divorce compared to others who have gone through it. It'll give you some immediate results to kind of look at. And if you want, we can have a conversation to interpret those results and see how we can help you through this process. So go to the website and click on the divorce quiz at thedivorcedadvocate.com, or you can go directly at thedivorcequiz.com. Again, thedivorcequiz.com. All right, let's talk a little bit about custody battles. And my guest today is an expert about this. He is an attorney, writer, entrepreneur, and host of the Law of Fojo podcast. He's a graduate of Harvard Law School and has spent 17 years in private practice, of which 7 years included handling divorce and parenting cases. Additionally, he is a fellow divorced dad of 3 children with whom he went through not one, but 2 custody battles. Please welcome Robert Fojo. How you doing, Robert?
Great. Glad to be here. Thank you for having me. And I appreciate the topic. I think this is an often forgotten segment of the population. They get short shrift. They don't get the same kind of attention and praise that divorced moms or single moms get. And I think that divorced dads need support. And I think that having this conversation, having this kind of podcast is a great way to build up that support and to increase awareness and educate our fellow divorced dads.
Yeah, absolutely. You know, from one divorced dad to another divorced dad, it's into all the divorced or divorcing dads out there. It's not exactly what you said is 100% true. We don't hear how valuable we are. We don't hear how important it is through this process that we need to be spending time with our kids, or the kids deserve to be spending time with us. And so we continually, at least on this show, emphasize that with all of the dads. So and part of that is sometimes we got to battle for it, right? We got to we've got the many states are getting better. Some states are still atrocious as far as the parenting time, and oftentimes that becomes a huge custody battle. But before we dive deep into that, share with the audience a little bit about yourself and then maybe a little bit about your divorce and your kiddos too.
Sure. Well, I sort of fell into divorce and family law practice when I started my own firm. I left a large firm in September of 2014, and I started my own firm. And inevitably, a lot of the work that tends to roll in through the door when you're a solo practitioner is parents going through divorces, custody battles, child support modification, disputes. And so I started to do that because that was the work that was available, and I learned a lot. Then a few months later, I learned the hard way when I myself got divorced. That was a very contentious proceeding. It lasted about a year. It involved initially the arrest of my ex-wife for domestic violence. And somehow following that incident, I somehow lost custody of my kids. It was a bizarre set of circumstances. A lot of the detail I'll kind of leave out, but it took me a few months to get them back. Essentially, I had lost them for the summer. It took until mediation that fall to set up a 50-50 parenting plan. And from that point forward, that's what I had. But then we got involved in another custody battle 2.5 years later, which was extremely traumatic for me. And again, it took me several months. The first time around, I hired an attorney. The second time around, I represented myself because I thought simply that I could do a better job than the other attorneys that I had come into contact with. And I eventually got the kids back. But both experiences were traumatic. Losing your kids can be very traumatic. And I learned a lot in that process. But over the last 7 years, I initially fell into the practice, and then I would occasionally take cases, and I would be very selective, but I kind of always had a soft spot for dads going through this kind of thing, because I think that the family courts tend to be very biased. Child support orders are always biased. Somehow the man always ends up paying child support. Judges always assume that dads are deadbeats and moms are the ones that have always shouldered the burdens of their children, of child rearing, and so on and so forth. And so I've represented a lot of dads in family court. I have represented them in a variety of capacities, not only in divorces, but in custody battles and child support modifications. Those are huge because those turn into essentially financial cases where you're looking at financial statements, income, especially with business owners. And I've been doing that for about 7-8 years. I've been since transitioning out of the law, but a good part of my practice has been family law practice and representing divorced dads.
Okay. Wow. That's, I wanted to say one thing is you made the comments about the courts often are giving more parenting time or are awarding inequitable child support to one party or the other, typically mothers. This is supported by research and data. So it's not a statement that is a speculative statement that you're making here. There's research around this. There's reports, there's data. This all supports it. Now, not that wasn't necessarily okay at some point in the past, but where we're getting now socially, economically, and with the dynamics of parenting, has not caught up in the court system.
Right.
Is that a fair assessment of kind of what you're saying? And I just want to point that out to people, because people are always like, oh, well, you're just your dads and you're biased about this, et cetera. It has nothing to do with that. It has to do with really trying to find an equitable way for everybody to move forward, because if one party or the other, and this goes to the flip side too, if one party or the other is suffering, not only mentally or emotionally, but financially, that puts a burden on them that is then a burden that's put on the children. And so the fact that the court system has not caught up with this to make this more equitable puts a great challenge on dads, and puts a great burden on the kids. Would you agree?
Absolutely. I agree with the research. I'm aware of the research, but I can also tell you just from my own personal and mostly professional experience that bias exists. Judges, for whatever reason, they walk in with a set of prejudices and biases. They see the man and the woman, and they automatically, in many instances, not all judges are like this. They're obviously more fair and even-handed judges, but they automatically assume that the mom's the one shouldering all the burden. The dad is some form of a deadbeat dad. And I can understand where and how they come to that assessment, because if you want to imagine as a judge, you've got hundreds, maybe even 1,000 cases on your docket. How many of these cases roll through? You have self-represented parties, and many cases involve people that are low income wage earners who have addiction problems and other issues. And there are certainly a lot of deadbeat parents out there. And at times they often involve fathers. So a judge who sees all this rolling through his or her courtroom, you're a human being. Judges are humans. They're not robots. They develop a built-in set of prejudices and biases. And so inevitably they approach many of the cases in front of them with that bias and they apply it that way. And it's not fair. They're not taking each situation on a case-by-case basis, and they need to approach these disputes with a clean slate and an open mind. And that often doesn't happen, unfortunately.
Yeah. So let's talk about why it's important to prepare for the potential of a custody battle. And I get men in our group meetings, or I get men in the private coaching that have the best intentions and say things like, "Oh, I just want to do this amicably. Oh, we're not, she's going to put the kids first." And then what happens is they start to get into this process, and then it might not be full-blown parental alienation, but stuff starts to happen where there's manipulation of the kids and the time frame, et cetera. So let's start with first, why is it important to start preparing? And then let's talk about some ways to start preparing if you are going to end up at a hearing and in court.
Sure. As far as why it's important to start preparing, I think you hit the nail right on the head. No matter how much either side stresses that the process is going to be amicable, they're going to work together. This is all about the kids. Let's just divvy everything up 50-50. Let's come up with a 50-50 arrangement. Inevitably, it all goes south. And I can tell you that from personal experience. My ex-wife and I discussed it in the same way, and then everything blew up. And I can tell you from professional experience that there's no such thing as a happy divorce. I'm being extremely cynical, but that's just the reality. So you do have to prepare for the worst case scenario. And that's why it's important to do so. As far as what you can do to prepare, I've developed a list of tasks or items, I suppose, that fathers can begin to put into motion in order to prepare for what may inevitably come. I call it the playbook, if you will, but it's something that I just kind of been working around in my head. But the first thing you should do, if you think that you have a divorce in the cards and you're looking at something a few months down the line and potentially there may be a custody battle, is contact an attorney. And I know that costs money. I know that is going to require an investment of time and money, but it's the most prudent thing to do, because you can get someone up to speed on what's going on and have them ready to go if things do go south. You obviously don't have to disclose that to your spouse, but it's a necessary step. And I think it's a prudent and very intelligent step, rather than finding an attorney on the fly once you get the divorce papers in the mail or an ex parte order, wherein you've either lost partial or full custody of your children. So contacting an attorney is a very prudent initial step to take. Another step that a father
can I ask you a quick question? So let's think of this from you say prepare for the worst case scenario, and I like that you say that, because if you're doing that and if you utilize that mindset that, okay, and this is prudent advice in life, right? In general, if you're preparing for the worst case scenario, things can only happen in a better fashion, in a better manner, if you are prepared for a worst case scenario. But if you're not, like you just described, and you haven't talked to an attorney, you become the respondent, et cetera, then you're behind the 8 ball. But if you've thought about this, if you think this is coming, or if this is headed, or here's the one: if she said, "I want a divorce," believe her. Believe her, and then start doing something about it. Don't just wait or hope that things are going to change, or think that just jumping into therapy. Start making some worst case scenario preparations right there. Believe somebody when they tell you something, and if they're talking about divorce, that's the time you got. That's your wake up call. That's your stick.
Yeah.
And then to the fact about hiring an attorney, or at least contacting an attorney, getting would you say getting up to speed and understanding, not only contacting an attorney, but learning the law and what's going on, what that process is. along the lines of that, so that when you do get it to sit down with an attorney, you kind of have an idea of what's going on.
Absolutely. That was actually the second item I was going to identify.
Oh man, you didn't even prompt me.
You're ahead of me on this one.
All right. Well then, before we get there, let me ask you one other question, okay?
Sure.
Which is there a benefit to being the plaintiff or the respondent?
That's a
and
great
for those
question.
of you who don't know the difference, the plaintiff is the one who files the motion for the divorce. The respondent is the one who is going to respond to it.
It depends on what the facts and allegations are. In a situation that doesn't involve any red flag events like domestic violence or adultery, I don't think it truly matters. But if there is a domestic violence incident that initiates the divorce process, if there's someone's cheating, and then the person who's been wronged files for divorce as the petitioner or the plaintiff, then it does make a difference. But otherwise, without those types of events that would prompt the divorce filing, I don't think it generally makes a difference, or at least I haven't seen it in my own practice where it makes a difference.
Okay, so from a legal perspective, there's really no benefit to being a plaintiff or a respondent.
Yeah, generally speaking, unless, as I mentioned, there is some intervening event that prompts it, and then in that case, the petitioner or the plaintiff is likely going to be or come off as the more sympathetic party.
Gotcha. Okay. Now, aside from the legal perspective, it has been my experience that with most men, it is more beneficial to be the plaintiff, the one that files the motion, because it allows us the opportunity to be moving something forward. And we have this masculine nature of wanting to have a linear process, which this process isn't linear, but at least being the plaintiff allows you to be taking steps to moving in a direction that could potentially resolve some of this. And so I don't know if that was your experience. I don't know if you were the plaintiff or the respondent. I know in my case, I was the plaintiff. And in lots of times, and I've talked to men who have been on both sides of this, that being the respondent was very challenging because they felt like they were reactionary instead of moving forward with stuff.
I hate to sound like the lawyer in this, but it depends. So if it really depends on what is being filed. For example, whomever the plaintiff is, doesn't really matter at that point if the respondent or the defendant files a motion for a temporary parenting plan and lays out a whole set of facts concerning the relationship of the parties, the parenting of the children, and how a custody arrangement should proceed. In that instance, even though the respondent is the one who filed the motion, that individual is driving the narrative at that point because you have filed the motion. In many instances, someone will file for divorce but not file any motion for temporary orders. And you, at least in New Hampshire and Massachusetts, and I'm sure in many other states, you can do that. You can file the divorce petition along with a motion or request for a temporary order setting a temporary parenting plan in place, a temporary child support order. Sometimes plaintiffs or petitioners don't do that. In that instance, the respondent can do it. And I think that in that scenario, the respondent is the one driving the narrative. And I think it's all about, I think that's what you're trying to get at, driving the narrative, setting the narrative, and framing everything in a way that
Correct.
benefits you.
Yeah. Well, that's a good point then. If you are the one that receives papers, then perhaps it's time for you to really take stock and look at what it is and how you want to go through this process. And that part of that, like you said, was talking to an attorney, right? Maybe getting a therapist, a financial planner, a coach, your team together as soon as possible, and then starting to create the vision of how you want to go through this process and through this divorce, and putting a game plan together. And then, like you said, creating that worst case scenario and then working backwards from there. So I think that's a really great point for those listening, that whether you are filing or whether you were served, that as soon as this happens, or as soon as you think that this is going to start to happen, to really don't bury your head in the sand, really start taking action and start doing something around this. Otherwise, you're going to be reactionary and you're going to be on your heels, and it could potentially make it more challenging. You're
I think that taking those preemptive steps is very smart. If you're filing the petition, you should develop a strategy for filing a motion for temporary orders along with the petition, so you can get something set in stone right away. You should obviously be talking to an accountant or financial planner, get your taxes squared away. If counseling is a component that needs to be incorporated, then you should be talking to somebody. And then there are other features and components of preparation that I can get into further in the conversation, or that I can identify whenever you'd like. But all of those things you should be thinking about before things get rolling. And that's the first step, I think, is always talking to an attorney, because they can help you identify the different things you should be doing to strategize for the filing.
Okay. All right. Perfect. Good. So what was step 2?
Step 2 is, I think you touched on this, it was understanding the law. There are two principal components to a divorce. One is obviously the children, and then there is the assets and / child support. A lot of people go into this thinking with misconceptions about the process. A lot of people think, well, if you have 50-50 custody, you shouldn't have to pay child support. That's not true. At least in the states that I've practiced in, it's not true. There's always a support obligation. It doesn't matter if you have 50-50 custody down the middle. So an attorney can help explain the legal requirements that govern these different areas, and what you're looking at in terms of, what's your income, what's her income, what is the support obligation going to look like here. If you want to, you can request no support for various reasons. The courts can usually deviate from the child support guidelines depending on certain factors. An attorney can explain all that to you. Parenting arrangements, an attorney can help you understand what it's going to take to get the kind of parenting arrangement that you want, and what factors go into how that's going to play out and how that's going to be developed. An attorney can help you understand the importance of mediation. I think mediation is always a very huge component of a proceeding, because it's much better for you two to make decisions and figure things out rather than have a stranger judge make decisions for you that knows nothing about you. And then, of course, if you have significant assets in play, such as a house, a business, a boat, anything like that, an attorney will help you understand how to go about, especially with the business. Businesses can be hotly contested, especially if the other spouse has some involvement in it. An attorney can help you understand how to go about concocting a strategy to divide assets, including a business that may or may not be worth a significant sum of money. That'll be a factor.
Stay with us. We'll be right back.
Hey, this is Jude with a quick reminder about the Divorced Advocate Foundation for Fathers, which is our nonprofit that helps dads through divorce with legal education, free or reduced cost coaching, and mental health resources. If you own a business or know someone who does, there's an easy way to help by connecting credit card processing through our partner program. Part of the fees go straight to the foundation with no added cost to the business, and 98% of businesses are actually able to save money on their processing fees. It's a win-win. So if you know a business that accepts credit cards, get them in touch with me by sending a warm introduction email to jude@thedivorcedadvocate.com, or give me a call directly at 720-255-1021.
So an attorney can help with all of that stuff. One thing that was really disconcerting for me, and I hear a lot of the times, we don't go through this hopefully more than one time, right? This process. And just like anything that is the first that you do for the first time, or that you try, it's very uncertain. And one of the guys in one of our group calls had a suggestion to get comfortable to understanding actually the process of being in court. And that was to go and watch some divorce proceedings, and watch how the judge or magistrates interact, how the attorneys interact, how there might be interviews or witnesses, and just go through the whole thing. Do you think that's a good idea for somebody to get themselves up to speed now? Because that's different than getting up to speed on the law and and all the legalities of it. But getting comfortable with. I know the first time for temporaries that I was on the stand, I was nervous as heck. I was sweating. It was very, very scary.
I think that's a great idea. I always I would find myself explaining to clients what to expect at a court hearing, and I'm literally walking them through step by step what's going to happen, because I've obviously seen it many, many times. But many people in those situations have had no exposure to this whatsoever. So I think that it is a great idea to go sit in on hearings. You can look them up on the court websites. They have dockets, and you can just go sit in. It's a public proceeding and just observe. And I think that's a great way to get some exposure to the process, so that it lessens the sort of the shock value of being in it yourself when that time comes. Because it's not Judge Judy. It's not how you see it in the movie and TV. Court is nothing like what you see in those media. So it's very different. A lot of these hearings, especially the preliminary hearings, proceed by what are called offers of proof. There's no testimony, live testimony. It's just the attorneys presenting information. Judges may or may not take exhibits or evidence in those types of hearings. Judges are all different. Some of them will just sit there and take notes, not even look at you. Others will take no notes and just look at you and engage you. Some are very nice. Some are much more hostile. So it's a great way to get exposure.
Yeah, and it also will give you an idea if you go to the court in your area, or where you will be filing, or where you have been filing, to get an idea of the judge, especially if one's already been assigned to you to sit and watch and understand it.
Absolutely, and if depending on what size area you live in, for example. In New Hampshire, usually every family court has one judge that deals with the family law cases. So if you go to that court and you sit in on hearings, you're going to be seeing the judge you'll be dealing with if you end up there. Obviously, in other cities and towns may be larger, you may have different judges, but it never hurts to go and sit in and observe these judges and how they conduct these hearings, so that you know what to expect if you're in that situation.
Yeah, and hopefully you never get to the point where I'm at, where now it's just a comfortable thing to go.
Yeah, you want to be showing up and saying, "Hi, Judge, nice to be back."
Yeah, it's not on my Christmas card list. So, all right. So, contact the attorney, get up to speed with the law process, and if you can figure out a time to go and kind of see what it's like to be in court, and how the attorneys interact, and how the judge interacts, and what that's like, that'll help at least mitigate some of the fear like I had of getting up there and dealing with that. What next? The
next thing, and I think this is extremely important, is to get involved in your kids' lives. You don't want to be, I know dads who have no idea who their kids' teachers are in school, who work too much and don't make it to extracurricular activities or sporting events. You don't want to be that dad that is accused of being completely absent and even if you're working and providing, but you don't want to be the one who's accused of being absent. So you should get involved, and you shouldn't do it purely for strategic purposes. You should obviously, even though that's obviously a component here, you should do it because you want to, because I think that'll have a more sustainable impact and a more long-lasting benefit. But get involved. Go to the soccer games. Go to the dance recitals. know who the teachers are, go to the parent-teacher conferences, read the emails that you get from the teachers, and be on top of your kids as far as homework, school projects. Take them to Staples to buy the poster board for the science project, and so on and so forth. Get involved and be involved, and do that as early as possible. Don't do it when the proceeding starts, because then that's when it's going to look like it's opportunistic. Do it early on, as early as possible, and do it because you want to. It will have a benefit.
Yeah, well, and if you didn't want to do it before, you're likely going to be forced to have to do it after, even if you don't do it during the proceedings, because you're going to be a single father after the divorce. So there's no time better than the present to start getting involved and making whatever lifestyle adjustments or changes you might need to do in order to be involved, cut back on some work, spend some more time, make some changes or whatever that might be. So
that's a great point. Because when it's your parenting time and you're the one's got to figure everything out, especially if it's not an amicable situation, you're going to have to figure things out yourself. So it would behoove you to get involved and to do it early and make it meaningful. Yeah,
absolutely. What is next? On that note, getting involved with kids. Do you recommend? So let's say you're starting the process. Do you recommend moving out of the marital home or staying in the marital home? And I ask that, it's a little bit off of preparing for, but it does have some impact on how much involvement you have with the kids on an everyday basis. And oftentimes I get guys that go, look, it was just too contentious and I don't want it to be like that for the kids. And so I'm going to move out and take the high road.
I mean, it depends. There it is again. It depends on a number of factors. So if you are in a contentious situation, all right, if you're having daily arguments and these things are, scream out loud affairs, then you should separate yourselves. Someone should leave the home and take up residence somewhere else, because there's so much potential for bad things to happen. That is an environment that frequently produces domestic violence incidents. And I'm not talking about somebody beating the crap out of somebody else. I'm talking about, an argument that's loud enough to prompt a neighbor to call the police. Police show up, police see a dent in the wall, they will arrest somebody. That will be criminal mischief and someone's getting charged. And all of a sudden you have a serious problem on your hands that's going to impact the divorce process. Because you don't want to be the person who is charged with domestic violence right at the beginning of a divorce proceeding. That's going to work against you in many, many ways. So if you have a contentious relationship, it is advisable for somebody to move out. Now, if you move out, you should consider the possibility that you may not end up living in that home going forward, that home is going to be awarded to the other spouse. It's usually what happens. It depends on the situation. If you're the one who could afford the home, then you'll likely end up back there if you want it. But if you move out and the other person can afford living there, you're likely not going to live there in the future. So if you particularly like living there and don't want to lose the home and want to continue living there after the divorce, then you should consider trying to stay and figuring out some other arrangement. With respect to the children, if you move out, make sure you have an arrangement in place. If you have not filed for divorce yet, make sure you have a parenting arrangement in place. You've agreed to it, and maybe you reduce it to an email, put it in writing somehow, and memorialize it, and that you follow that. Because if you have something that you're following that's in writing that both parties agreed to when things were still okay, you can use that to support your request to continue that arrangement in the divorce proceeding, to request a temporary order that proceeding be implemented. So if you move out, don't just move out and say, okay, I'll swing by on Friday and come see him, or I'll pick him up, take him to the movies, and make it sporadic, or make it something that's infrequent and not consistent. Get something that's consistent and memorialize it in writing, and make sure the other side agrees to it.
Right. That's a huge point, because I hear all of the time that, yeah, it was like I alluded to earlier. We're going to do this nicely. We're going to be amicable. And then the dad moves out, and then they don't have an agreement. They haven't had any set time. They're not in court yet to have a temporary agreement. And then it starts, well, you can't see the kids, or there's restriction, there's gatekeeping, and then it becomes a giant nightmare. And then then you're really gearing up for, but in the meantime, like you said, and was your experience with having to deal with not seeing your kids for a great period of time, there can be a ton of damage that is done in that time frame with the kids.
Yeah, and it works to your benefit too, and for the children's benefit if you maintain a consistent and constant presence in their lives. And even if it's coming by, if you come up with something that resembles a 50-50 arrangement, even if you swing by and see them for a couple hours, here and there, outside of that schedule, that works wonders for them, because you maintain that relationship with them, you maintain that connection with them. And especially if they're not young kids, if they're a little older, they will notice that, they will acknowledge that, and understand, how much you value your relationship with them.
Yeah. And just make sure whatever agreement you agree to, that you perform on it. So you're not looking like you're not doing it. You don't want to be accused of relinquishing parenting time. Yeah, exactly. Okay. What's next?
What's next is it's critical that you don't confide in your children concerning whatever problems you're having with mom. Don't ever make any derogatory comments about mom in front of your children or to them. If they're older, 11, 12, 13, they kind of see things and understand things. Make sure you keep them insulated. Don't vent to them. Don't take out your frustrations on them. Whatever the situation between you and the soon-to-be ex or the ex, keep it between you two and put on a happy show for your kids. They will, even if they see things, even if they recognize that mom may have a drinking problem or mom may have this kind of issue or that issue, never, ever validate those concerns. Never, ever demonstrate any kind of disrespect towards their mother. Keep it kosher. Your kids in the long run will value that. They will appreciate that, and they will respect you for it. And in a divorce proceeding, that's going to work wonders for you, because you won't hear. In family court, people throw all sorts of mud on the wall. I have never been in a situation before I started doing family court cases. I was in superior court, federal court, where people actually had to support the things that they say or in front of a judge. In family court, all that's out the window and no one gives a shit, excuse me. They will throw mud and allegations out of nowhere at you. And you're going to sit there and wonder, where the hell is this coming from? The last thing you want among those type, and it's going to happen, but the last thing you want is, little Johnny said that dad said this about mom, and you don't want to deal with that. Okay.
Right.
Because the kid's not going to be there to testify. It's going to be an allegation from the other lawyer, and there's no way you're going to be able to disprove that. But now it's in the judge's head, and you have to figure out do I address it? Do I try to explain it? So if you will avoid those situations, if you leave your kids out of this, make this between you and her, and keep it that way.
Well, and what I'm hearing you say also is that there's kind of there's two aspects to this. One is if we're talking the worst case scenario, which is what we're working backwards from, is that if this goes to, say, like a PRE, a parental responsibility evaluation, or a child family investigation or something like that, if you're talking bad, that's going to be shared potentially in that circumstance, and that's not going to look. Number one is the other flip side of that is it's damaging your relationship with your child. So it's just bad. It's bad to do on both counts. It's going to be a problem for you. And then relationally, it's going to be a problem for you. Your children derive part of their personality from both parents, no matter how egregious one or the other parent's actions have been through this process. So by bad mouthing the parent, you're bad mouthing your children, and all you're doing is harm to them and your relationship with them. So just don't do it. Now, that's not to say if there's a behavior that is inappropriate, and say somebody's talking, your soon-to-be ex is talking bad about you, you can say, I'm sorry that your mom is saying that. She shouldn't be saying that about me, or she shouldn't be doing that, and I'm sorry. You can address it that way. That's not bad. That's not bad mouthing anybody. You don't want to do that, or you can do that, but make sure not to badmouth. It's just, there's no good scenario. There's nothing that can possibly come of it. If you need therapy and you need to vent to somebody, go get therapy, get a coach, go find a buddy or somebody to do something, but do not do it to your kids, because it's bad all the way around. It's bad
Absolutely.
all the way around.
I agree. Obviously acknowledge it, but reassure them that, everything's fine, and say, I'll let me talk to mom, but I don't worry about it. Mom loves you, etc. But yeah, these are all, this isn't just strategically for the proceeding. This is something that, as you mentioned, it's going to benefit you in the long run, by maintaining that respect with your kids, and improving and culturing and nurturing that relationship.
Yeah. And as hard as it may be to hear some of that stuff coming from your kids, that your ex or soon to be ex might be saying, that eventually, this might be your experience too, Robert. It's been mine with my kids. They figure this stuff out. My kids were young. My kids were young when we started, when we got divorced, but they'll figure it out. And the better you can be about taking the high road, the better you can be about creating an environment that is loving, and you listen to them, but not put them in the middle of it, and not badmouth your ex, that they're going to see the difference over time, and they're going to understand this, because they're a lot more intuitive than we give them credit for.
Absolutely. They're intuitive, they're resilient. They will notice a lot of things. So the more effectively you play things close to the vest, obviously acknowledge any issues they raise, but otherwise keep them out of it. They're young. They don't need that kind of stress anyway.
Yeah. Good. Okay. What's next?
Stay civil in your communications with your soon-to-be ex. And by that, I mean text messages and emails. The last thing you want is a text message littered with F-bombs in front of a judge. That's happened to me. It's happened to my clients. First thing I always tell them, keep it cool with text messages. I don't want to have to deal with a text message, because you can have 100 wonderful and nurturing communications with her, but that one message where you lost your shit is going to end up in front of the judge, and that will forever define you. Keep it cool, and don't say anything that you don't want printed on the front page of the New York Times.
Yeah.
No matter how much you want to get at the other person and get at their throats, maintain your composure. It is so important, because if a judge sees stuff like that, they're going to draw the wrong conclusions.
Yeah. So I'm going to give a couple of tips around this that I learned. And one was, don't respond for 24 hours unless it's an emergency.
Yep.
So just because especially when you're in the middle of it and things are contentious and your emotions are high and things are coming up and you got the kid, like all this stuff going on, if it doesn't need an immediate response, don't respond. Take 24 hours. Even if you want to type out your response and wait 24 hours to send it.
Yeah.
The other one,
I actually follow that myself.
Yeah, me too.
Whenever my ex wants to start something, it's always 8, 9, 10 o'clock at night. She's a couple of glasses of wine in, and she sends me something, and it's clearly intended to just elicit a fight. I just put my phone down and I decide I'll answer it in the morning. And the next morning, I'm a lot less likely to say anything I'll regret.
Yeah. Well, and that goes like what you just said, is find a time where you're going to check these emails specifically. You can have the emails go into a certain folder if you want, or if you do Talking Parents or Our Family Wizard, you check it at a specific time where you're mentally and emotionally prepared and ready to read whatever is going to be coming through. And you're not, like you said, doing it while you're eating dinner, doing it while you're on the golf course, doing it while you're with the kids, or whatever else you might be doing that it's going to ruin your day or get you upset or whatever else. It just will get you in a better mindset. And then the last one is if you really need a buffer, have a friend read your email first. I mean, have it just forward them. Forward your texts. Yeah, just look at this and do I need to be prepared or is it no big deal? And that might help also.
Yeah, because that person is obviously removed from the emotions that are governing that situation, and that person can help you sanitize it, for lack of a better word, so that you don't send something that's going to make you look bad, going to make you look like the aggressor, and ultimately shoot you in the foot when you don't need to make mistakes in these proceedings. You want to press forward and get what you need, what you're entitled to out of it. Get time with your kids, get a fair child support order, get a fair division of assets. You don't need to be shooting yourself in the foot with these types of mistakes.
Yeah, just remember it's a marathon. It's not a sprint, because it's going to be a process. It's going to take some time, and the more time you take to think through this stuff, the more positive outcome that's going to have a long-term effect with your kids. Because here's the other thing, and I'd like your thoughts about this, because this is pertinent to like being reactionary, is that making sure that you go through this process and be diligent. You just said it. You don't need to make these mistakes, right? Make sure that you're really being diligent and taking your time through this process. Oftentimes, I hear guys say, "I just want to get it over with," and that's understandable. But you got to remember that this is, especially if you have younger kids, this is going to be the agreement until you have to come back to the court, which you don't want to do, for a very long time.
Yeah, this is a process that is going to, depending on how old your kids are, but even outside of that, with respect to how you divide assets, this is a process that's going to impact the next, decade, 2 decades of your life. So you should allocate the attention that it deserves and allocate the effort that it requires.
Yeah. All right. What's next?
What's next is, this is sort of a spin-off of the prior one. Clean up your social media. People do this all the time. I've had clients do it, and it infuriates me. There's two ways it can go. One is you vent on social media about your spouse. You haven't cleaned up your friends list, and a mutual friend sees it, forwards it to her, and all of a sudden they have a new exhibit to use at a hearing. You don't need that. I had a situation. Another way it could go. I had a situation with a client. It was a child support modification. So he had lost his job. We were trying to modify his child support. He was paying $4,250 a month. Okay. He had a yacht. He was doing very well for himself. Lost his job. It's terrible. So we obviously needed to modify child support. Well, he put the boat for sale, but he kept using it. He posted pictures on Facebook with him and his kids on the boat. And I saw them one time. I texted him. I said, "Take those down." He's like, "No, it's my boat. I want to use it." I take it down. Someone's going to screenshot that, and it's going to be used against you. Take it down. He's like, no, he didn't take it down. The child support referee hearing. Guess what Exhibit A was?
Yeah.
It didn't matter that he had the boat for sale. Didn't matter that he was trying to sell it. He was doing the right thing with it. He was trying to get rid of it. Optics is all that matters at times in these hearings. And you throw a picture like that in front of a child support referee, they're going to look at that and they're going to conclude, if you have the time and the money to be maintaining that boat and taking it out, you have the resources to continue paying child support or not get the modification that you want. So
yeah,
2 different ways that social media can work against you. Clean it up. Don't post anything negative about your spouse, the proceeding, and don't post anything that can be used against you like that.
Let's talk a little bit about what you alluded to in this content, alluded to earlier, about you're having somebody make a quick decision about an important part of your life that's going to impact you and your children ongoing, and they barely know you, and they're barely spending any time with you. And so that goes to this point. You don't want somebody that's going to, like, it's first impressions, right? It's going to be whatever first impression this judge or magistrate has of you. And if the opposing party is able to bring stuff that makes you kind of seem like not a good guy or doing something that's not appropriate, then that, and that's not just along the lines of social media, right? That can be anywhere in your life and any way that you might be conducting yourself in your life, whether it's finances or dating or whatever else, that, you know, you're going to be in front of a judge. So if you can't at least try to control yourself through the divorce process, right? In some of this stuff, and when you're done, you can do whatever you,
when you're done, do whatever
you want. Yeah.
But when you're done, if you want to post away, do whatever you want. But during the process or immediately before the process, keep everything neutral and don't put anything out there that can be used against you, and use your common sense.
Yeah. And if you don't have common sense, ask your friend or ask your attorney. Your attorney will tell you. For
Absolutely.
sure.
That's another important reason why you should talk to an attorney. An attorney will tell you the same thing I'm saying right now. Clean up your social media. I mean, and I'm saying, don't do anything going forward on social media that would help you, but also look back up in that last few months and see if you posted anything that is questionable and just delete it.
Yeah. Yep. Okay. What's next?
The last tip is, a lot of people don't know this, but if you maintain a journal, think of a handwritten journal, and I think that's probably the best way to do it. A contemporaneous journal, day to day, describing things about your relationship, your kids, and any other significant events that pop up, and you keep that for a period of time, that is evidence that you can use at a hearing or in a divorce proceeding. It's considered hearsay because it is a series of statements that were prepared outside of court, and you're introducing them as evidence to prove whatever it is those statements say, but they fall under an exception to the hearsay rule. So It's admissible evidence. And if you, for example, if she is alleging that you've had no involvement in the kids' lives in the months leading up to the divorce, that you produce a journal, it's dated, September 1st. I went to Jimmy's soccer game today. It was awesome. He scored 2 goals, etc. Next day, I picked the kids up. We went to the movies, and if you record events like that and interactions like that, that will be considered admissible evidence that you can use to refute arguments like that. It's counterintuitive. People don't do that. People don't keep journals anymore. But I always tell my clients the minute they walk in my door in a situation like this, especially if something hasn't been filed, to keep a journal daily or every other day, describe things and events that are happening, because that can be beneficial in the future.
Absolutely. So I'm a big fan of journaling. We talk about it a lot on the show, and this is just one more. And this is not something that I'd ever heard or I'd ever thought about, as far as it being an opportunity to provide evidence to dispute some allegations. So just another one. And you're saying start as soon as you think that this process is going to happen, start journaling about your days, the kids, kind of your interactions with them, as well as whatever prompts you might have in the journaling as far as what you're thinking and how you're feeling.
Right. Start it as soon as you can. If you start it right at the beginning of the proceeding, it's still admissible, but it's less probative because it looks opportunistic at that point.
Right.
If you think that the relationship is going south, or someone says, I want a divorce, I'd start keeping a journal. Okay.
Well, that's just another reason, gentlemen, to start journaling sooner than later. It'll help you mentally, emotionally, but it's also going to potentially be some evidence. So, all right. Well, Robert, that is a lot of information. Let's go through these again real briefly, so we can summarize them with everybody. First one was prepare for the worst case scenario.
Prepare for the worst case scenario. Contact an attorney.
Contact an attorney. Second was get up to
Understand.
speed with the legal process and what the law is in your particular state. And we should probably said this in the beginning, is that we are not giving any legal advice on this show. We are just talking about the legal process and speculating about things that we have seen and experienced in our respective practices. So none of this is legal advice, and we don't expect you, wherever you're at in the States or the world, to follow this as legal advice. So the next one is don't confide or get involved in your children's lives, right?
That's right. That's right.
And the next one was don't confide in your children, keep it above board, take the high road, and do not badmouth your ex or soon to be ex. The next tip for preparing is stay civil. Use some of those tips that we talked about.
Stay civil in your communications.
In your communications, right? Mm-hmm. The next one is clean up your social media or your life in general, if you need to be doing a little bit more cleaning up than just your social media. So some of us do, right? And then your last tip was begin keeping a journal as soon as possible.
Right.
Awesome. That is a ton of valuable information, Robert. I really, really appreciate it. Where can our listeners get a hold of you? How can they plug into the Law of Fojo podcast? And you've got a lot of good info on there as well.
They can go to lawoffojo.com or just simply podcast.lawoffojo.com. And I'm also on Twitter. My Twitter handle is Law of Fojo.
Okay. And is there any other social media where they can connect with you, or a website, or you said the website?
I have a Facebook page and Instagram page as well. The handles are the same, Law of Fojo.
Okay. No TikTok?
I actually started a TikTok page. I actually did start a TikTok page because I've seen some other personalities that I follow on Instagram with TikTok pages. I'm still, my kids are all on TikTok and they're much more proficient at it than I am.
I know.
I post on it, but it's not. I'm still figuring out how to use it for the benefit of my podcast, and I still haven't quite figured it out. So I'll let you know if I do.
Yeah, when you do, let me know and you can teach me, because I haven't even, you're way ahead of me in just endeavoring into that. So, Robert, I really appreciate it today. And as always, if you found value in what we talked about, please share it with another divorced or divorcing dad. Like our YouTube channel, leave a comment. If you're listening on one of the podcast platforms, leave us a star rating or leave some comments. That helps us immensely. We continue to grow the divorced advocate community and help each other out. Robert, it was such a pleasure having you here today, and have a great one.
My pleasure as well. Thank you very much.
To hear the rest of this episode and access the corresponding resources, visit thedivorcedadvocate.com and become a member of our community. It's free to join and will provide you with the resources you deserve as a divorced or divorcing dad. Thank you for listening. God bless, and I'll talk with you next week.